So today we're going to talk about the court process and some of the case law that set the standard. I might come back to the DCF regulations and rules a little bit, but I'd like to actually start with the case law portion and the court process. So when we met last week, we started talking about when a 51A report comes in, and if it's a case where the children are going to be removed, then the DCF has to do what? So today is Tuesday. If Elaine was like the caseworker and went out to a home today and was satisfied that there was reasonable cause to believe that children or a child were in immediate danger of neglect and abuse and actually took the kids out of the home, right? What's her duties under the statute pertaining to the filing a case in court? What would she have to do? Elaine, what do you have to do?
72 hours.
What's that?
72
So you pulled the kids today, 1 o'clock Tuesday, you went to somebody's home, you went to Mark's home, and Mark's home was in just a state, and he hadn't fed his 2-year-old since yesterday, and she was in wet diapers, and you had a report. Let's make the report be from a neighbor this time. But when the neighbor made the report and it was screened in, it was actually screened in as emergency. So you actually went to the home as soon as you could. So you ended up taking that baby from Mark's custody, again, Tuesday at 1 o'clock. What is the thing that you absolutely have to do under the statute, Joe?
I'm not sure if you're getting at the 72-hour hearing or...
No, what's the next? You guys are you like to jump ahead to the end. What happens before a 72-hour hearing? The child, let's call her Amy, is pulled, again, 1 o'clock on a Tuesday.
So you're hearing in court the next day.
They're gonna, you're going to go to court the next day, right? Right? To do what? Karen?
File an affidavit
Yeah?
to get an emergency hearing.
Okay, and it's along with the affidavit, obviously you've got to file the petition, just like with any court case, in the nature of a complaint, what's going to initiate the case is your petition under 119.24. Because under 51B, and what was it, subsection C, I think, that said if it's an emergency and you go out within your 2 hours and you end up pulling the kid, right? That now you've taken a child from Mark's custody. Mark's the parent. Remember all the due process cases that you've read. So Mark has some rights, but at the same time, just like in Prince v. Mass, the state has an interest in the protection of children. So in the scenario that I just gave you, the child, Elaine's determined that she's got reasonable cause, remember the standard? To believe that little Amy is in danger of abuse and neglect. Pulls Amy again on a Tuesday. That means that Wednesday, Elaine's going to go to court with her petition and her detailed affidavit. She's going to go before the judge for this emergency hearing under Section 24. And the standard, Sandy, before the judge now is what? So in order for the judge to say, oh yeah, Elaine, that's right, I'll give DCF custody. What does Elaine have to do? What does Elaine, if I'm the judge, what does Elaine have to convince me of?
Reasonable
No!
Reasonable cause.
Why is it not clear and convincing evidence. There's no evidence. There's no trial. It's an emergency hearing. It's a threshold kind of, you know, almost going to court to get like a ex parte order when there's an emergency type thing.
But don't you have to prove something that the baby was
Wait, you're all talking at once. What?
Don't you have to prove something that the baby was
You need to speak up. Mark can't hear you.
doesn't she have to prove something that the baby was neglected?
What does she have to prove before the judge at the emergency hearing, Kate?
She has to prove that neglect or abuse by a fair preponderance of the evidence.
This is Wednesday morning. There's probably no attorney there. There might be, like the DCF attorney might be in the courtroom. DCF attorney doesn't really even know about your case. The DCF attorney is doing all these other cases. Attorney for parents haven't even been appointed yet. The case is just coming in, hot off the press. She's got a petition in her affidavit that she walked in Wednesday morning to the clerk's office. She got it docketed. The clerk said, take it upstairs, go to Judge Blissman in session 1. The case gets called, and it's just Elaine. It's just Elaine with her petition and her affidavit. And the standard, Geneva? Stephanie?
I'm going to say reasonable cause.
You're going to say it because it's where? That standard is written somewhere in something I gave you.
Section 24.
It's in section 24. Oh! So let's just look at section 24 again. So it's in section 24. This is just an emergency.
Temporary custody.
Did I bring my statute? Yes. So if you look at section 24, third paragraph, if the court is satisfied after the petitioner testifies under oath, so that's Elaine, that there's reasonable cause to believe the child is suffering from serious abuse or neglect or is in immediate danger, and that immediate removal is necessary, the court may issue an emergency order transferring custody of the child. And I'm going to stop right there because then it says for up to 72 hours and then we get into the next hearing. So that's, the judge listens to her, says, okay, you swear to tell the truth, blah, blah, blah. She's got her petition, she's got her affidavit, the judge may ask her a few questions, and the judge is going to order temporary custody, emergency temporary custody to the department on that day. So Wednesday the 15th, DCF now gets custody of the child that they already pulled on Tuesday night. Everybody with me? Okay. So what else happens on that day? So what else happens on that day? She just filed a petition. Think of when you filed, a complaint against someone. What happens next? Maria? Notice. So notice is in your second paragraph. Notice to the department, summonses to both parents. If you look in the middle of this paragraph, and this can get kind of scary, it says in the notice, the summonses to the parents shall include notice that the court may dispense with the right of the parents to consent to adoption. What does that mean? So Mark gets his notice, and it says that, this came from the 11924, the allegations are in the first paragraph. The child is growing up without necessary and proper physical care. The circumstances damaging to the kid's development, lacks proper attention, and the parent is unwilling or unavailable, blah, blah, blah. The allegations, just like with the, torts case, for example, the complaint, the numbered, cause of action. So those are the general allegations. And along with the petition, he gets notice, his summons says, this could happen in this case. Termination, that the court could enter an order dispensing with your consent to adoption of your child. I want to hold that conversation because that goes to trial later on and disposition, but it's like the worst case scenario dispositional alternative of a case that begins like this, termination of parental rights. So as Maria said, parents get notice because it's due process. You have the right to appear before the court. Now, they haven't appeared before the court yet because the kids were taken on an emergency. Department ran in on the next business day, filed the petition. Now the parent gets notice. Another thing that's going to happen on the first day the case gets filed is under Section 29, right? The attorneys get appointed. So it's not until the case gets started that attorneys get appointed. This is particularly important in terms of the left side of the board where I've written the department's duties and obligations and what the department does as an agency. Suppose instead that the facts were not that much of an emergency nature. You know, neighbor called and said, you know, I hear a kid crying, and I think he's not taking proper, you know, care of his child. Sometimes you see the child, you know, on the second floor porch, you know, by herself in, you know, just a diaper and it's cold outside or that, something of that nature. And DCF goes and, you know, interviews, does the investigation, you know, finds perhaps that there's reasonable cause to support the 51A report, but doesn't actually pull the child, all right? So now what DCF has done is DCF has made a determination internally as an agency that Mark is basically a perpetrator because he's going to end up in the central registry. I forgot what section that was. It might be 29 as well. He's going to end up on the central registry because a department employee has found reasonable cause to support, to substantiate a 51A. But in the scenario that I gave, the department has not taken the child on emergency, so that means the department may or may not file a care and protection case. Okay, just because the department is investigating and working with a family, because remember, Section 1, the purpose clause, strengthen and encourage family life, offer services, you know, do what they can as an agency, you know, parents patriae, super parent as an agency to see what they could. So maybe Mark's a single parent and he was a little bit, you know, overwhelmed, and he was studying for an exam, and little Amy, you know, opened the door and went out on the porch to look out, and whatever, okay. So now, Mark also has certain rights. If that was the case, and he said, you know what, they should not have found that employee, yeah, she should have investigated, fine, whatever, but then once I talked to her and whatnot, she should have said, okay, you know, you're fine, you know, and we're gonna close the case. But instead, she substantiated the report. I've got a right to take it further. And Mark could do that within, you know, within the agency's rules and regulations. And he's got a right to what's called a fair hearing. So he could go before the department, have a fair hearing, and the hearing officer would either, you know, affirm or, you know, reverse what the initial investigative social worker, you know, had done. So, you know, I'll get back to some of the departments, but keep that in mind that, you know, when cases go and get filed as care and protection cases, there are also hundreds or more, right, of other cases where the department is working with families but has not actually filed a care and protection case. So I said notice to the parents, notice to the parents. So a judge on that day of the emergency hearing is also going to appoint counsel for parents, counsel for child or children, also will appoint under Section 21 and 21A the court-appointed investigator. And we'll talk more about the court-appointed investigator in terms of special sort of evidentiary issues that occur in the juvenile court. So all of that happens on that first day. It's all the paperwork, you know, that goes out. So if you, say Uma was the attorney that got appointed, you know, for Mark, and if he, you know, typically in the juvenile court, you know, a lot of the attorneys that are doing under the Committee for Public Counsel, doing a lot of these cases, they may be around because they've done, you know, they've got all the cases that day. So Uma may or may not know on Wednesday that he got appointed to represent Mark. But in any event, he's going to know soon, and he's going to somehow obviously want to get together with Mark, because now Mark has a right, getting back to 11924, that third paragraph that mentions 72 hours. The court may issue an emergency order, that already happened, transferring custody of the child for up to 72 hours. And then the next paragraph takes us into the 72-hour hearing that the parties are entitled to. Any questions so far? Okay, so Mark has a right to a 72-hour hearing. It's a temporary custody hearing. Actually, Section 24 and Section 25 is also a temporary custody hearing that occurs when there isn't an emergency. So all parents have that right to come before the court and now have the court determine in more of a full-fledged hearing, because the emergency hearing was, you know, very low threshold, right, in terms of burden of proof, because of the emergency nature of the child being, you know, in danger of abuse or neglect. So he's got a right to have the court now, you know, make a further adjudication relative to custody. The burden of proof is not in the statute, and it's one of the cases that you had to read, the Robert case. So somebody tell me about Robert and the 72-hour hearing. And why in that year, what was the year? 88. 88?
1988.
What?
It started in 1988, like the facts. But
What's the decision? What's the year of decision?
1990.
In 1998, yeah, okay. So why in 1998 after, God, these kids.
1990.
1990, all right. I stand corrected. Why in 1990 after, oh God, I mean, these camp protection cases have been going on for like years and years and years and years with really no sort of burden of proof because it wasn't set anywhere. So what was the court's rationale in, first of all, what did Attorney Michael Kelly argue for in terms of, oh yeah, he'll be coming to talk to you guys when we get to, later on when we get to the chins, because he loves to take cases to the appeals court or the SJC and wins. So,
He's an excellent attorney.
and he's a great attorney. He frequently takes interns as well, so he's got one of my family law students this semester. So what was he arguing to the SJC in terms of parental rights in Robert? Amy?
He's arguing that they had a right to the 72-hour hearing, and that they can't take, because they can't take the child away from the parents, because it's their constitutional right under federal and state constitutions.
Yeah, remember back to those of you that had con law, the Matthews v. Eldridge test, right? How does the court use that test to come up with what standard of proof should apply in a temporary custody hearing? Am I not, if people are looking quizzically at me, who had con law in here? Did you read Matthews v. Eldridge? Oh, you didn't? No?
Yeah, we did.
Oh, okay. Who remembers it? I've taken it out of the CD, I think, because I used to have it in there.
They list the
You guys don't have it, right?
No, we don't.
Oh.
They list the standard on 150, but.
Yeah, one day just started.
Yeah, in the Robert case, right?
Yeah.
Okay, so tell me about it, Joe.
The private interest that will be they look at the private interest that will be affected by the official action. They look at the erroneous deprivation of the interest of the procedures used, and the government's interest, including the function involved in the fiscal administration of the
Okay, so let's go back to the first part, the private interest. So what is the private interest involved that it's at stake in a 72-hour temporary custody hearing?
Well, it's custody of the child, again, the parent's right to maintain control of the child.
Yeah, and this 72-hour hearing, and later on we're going to be talking about the trial. The trial's going to occur at the earliest under the statute, 15 months after little Amy was pulled from Mark. So that means that Mark doesn't have his child for at least 50 months. In this temporary custody hearing, while it's temporary custody and not a full-fledged trial, but it really sets the stage for the whole process. So in terms of what Joe said, very important in terms of, parental rights at stake. So what's the middle part, the risk of error piece of it?
Well, especially in this case where it's a father who's sort of doing his best and he doesn't have enough, it's a poverty issue where he doesn't have enough money for a proper apartment for 8 children or whatever. There could be that standard could deprive him of his right for that entire period of time. So it would be a high risk of error, I would think.
There would be a high risk of error if the standard was what?
If the standard is low.
If the standard was low.
And that's why in this case the guy's he's arguing for a higher standard, even higher than the one that the court comes out with.
He was actually arguing.
Clear and convincing.
Yeah.
But that's not what the court comes out with.
And why not? And then looking to the state's interest.
Well, we haven't had a full hearing, but this is a 72-hour hearing. We haven't presented evidence, so you're not going to get to the level of clear and convincing in a 72-hour, probably. So it should be a lower standard to give the person some sort of chance to maintain control of the children.
And what's the state's interest?
The welfare of the child.
The welfare of the child.
Best interest. Best interest.
Yeah.
The best interest of the child.
Well, what's the state's interest at the 72-hour hearing?
The safety of the child.
Yes, right. The safety. So it's still, you passed the emergency stage, but still, little Amy, the state is arguing, well, she's not ready to return home to Mark in 72-hour, within 72-hour hearings. Within 72 hours after removal, because, the circumstances that led the state to remove her in the first place have not been, fully rectified, fully looked into, etc. So the state still has an interest, but at the same time, as Joe said, it should be a little bit higher than just reasonable cause, because you saw reasonable cause with just the social worker pulling a kid, reasonable cause with the judge just sort of listening almost ex parte, to the social worker saying, I pulled his child because blah, blah, blah. So it is a little higher, and it's the fair preponderance of the evidence standard for Robert. But when you think of it, when I started practicing, there were no standards. There were no standards. So it wasn't in the statute, it wasn't in case law. There was a standard overall, and we'll get to the trial in a moment. But the, quote, 72-hour hearings looked almost like an extension of the emergency hearings. There were just more people involved because by that time the attorneys were in the picture and whatnot. So judges really didn't know what to do and frequently just extended the original emergency order. The other thing is that, again, the online students can't see me smile when I say 72 hours. 72 hours. They don't always happen in 72 hours. One big reason is the court's docket. Another big reason is that the parents might end up, for one reason or another, waiving the 72-hour hearing. It might be truly a circumstance where the parent isn't around and it truly has, abandoned or on the face of it doesn't care. Or it could be a concerned parent, but knowing sort of the negative facts that are gonna come out at the 72-hour hearing, has maybe decided strategically with his or her counsel, you know what, I don't want this to get in evidence right now. You know, maybe I can use the time to sort of get my act together. So I'll, you know, kind of waive custody for now and waive the 72-hour hearings. So that is, you know, possible as well. But it's certainly the parental right, and it's the state's burden, Joe.
Sometimes there could be a notice issue as well. I mean, getting both parents notified within 72 hours might be a problem.
True.
I mean, especially if it's two parents who live at different locations or.
That's true, and sometimes you have the parts unknown situation where you have to do the notice by publication. And so there are, yeah, again, a ton of other reasons why these temporary custody hearings don't occur within 72-hour hearings. Or they might start in 72 hours, in 72 hours, you know. Everybody appears in the morning, call the list. DCF says, I'm ready, Your Honor. Mom and dad's attorney, child says, we're ready. Okay, second call. Second call happens at 3 o'clock, and you've got an hour, maybe, you know, because then, you know, there might be housekeeping things to do before you actually get started. So now you're, say you're 72 hours after Wednesday, Friday? Somebody do the math for me. Oh, would it be the following Monday? Okay, so next Monday, the 20th. No, wait. Monday's a court holiday. So that means you're now talking about maybe Tuesday the 21st. So you go in Tuesday the 21st, again, call a list, blah, blah, blah. If you don't get started till 3 o'clock maybe, all right, then everybody looks at each other, all the attorneys have their books. All right, when are we going to continue this 72-hour hearing that we got maybe, you know, 20 minutes of today on Tuesday the 21st? Everybody looks in their books. And the clerk is there with the, you know, court calendar too. So we've got not only the judge's time, right? One attorney for the state, the department, an attorney for one parent. If there were two parents, it might be another attorney. Again, if there was more than one child, it might be, so you're talking about there might be at least 5 or 6 people looking at their books, trying to schedule when is the next available time to finish that 72-hour hearing. So you could conceivably have a 72-hour hearing that starts on one day and doesn't get finished for weeks and weeks and weeks. But again, you know, the standard and the rights that are involved, standards of preponderance, it can be like, it could take, depending on the simplicity and depending on stipulations and whatnot, it could take an hour, it could take days, because you have the right to a full-fledged trial with, you know, opening statements. You know, we did that little mini Jerry Golf case the other day with just one witness, the victim. So you could have, you know, multiple witnesses, direct examination, cross-examination, different attorneys doing cross-examination.
All in 72-hour hearing?
Yes, yeah. Again, because as I said, it's so important for parents, and if parents are really advocating against the department and they've got the attorneys and they've got the right. Remember, the section 21 says it's the rules of the common law, the rules of evidence. Just because we're in juvenile court doesn't mean that you don't have the right to challenge, to advocate, to use the rules of evidence as in any other court. So that's the 72-hour hearing. And I think I mentioned quickly before 29C that so the state not only has the preponderance of the evidence standard, but also has to certify that staying in the home is contrary to the child's best interest. So at the end of the 72-hour hearing, the judge actually has to sign a certification form that DCF has made reasonable efforts before removing the child. And there are exceptions, you know, when the child's been abandoned, the really serious felony type cases, and those exceptions are in the statute. But for the most part, because the judge is now, if the judge is going to be awarding custody to the department, the judge has to certify that continued custody with the department and the removal is necessary and the department made reasonable efforts before removing the child. Now, let me just jump to the final hearing, but then I want to get to some of the in-between stuff, and that's some of the other cases that you had. So the final hearing, the trial, 119, section 26. And you've read the case that sets the standard for the final hearing. The Santosky versus Kramer, the U.S. Supreme Court case. Santosky versus Kramer, I think that was the first case that you should have read for last Thursday. So when this case goes to trial, we now move from reasonable cause of the emergency hearing to preponderance of the evidence for the 72-hour hearing. When the case goes to trial, what is the department's burden of proof? Clear and convincing. And Santosky versus Kramer set, the umbrella set the stage and said, you know what, before you can, and actually that was a termination case, before you can irrevocably, remove the parental rights, the state has to prove unfitness by clear and convincing evidence. Now, we as a state obviously have to follow U.S. In terms of the minimum. So the minimum, when you go to trial in a care protection case, is clear and convincing evidence. I mean, Massachusetts could have decided what? To do what? And still comply.
Beyond reasonable doubt.
Right, right. Because the states are free to afford more rights, can't afford less. So we can't go less. So our statute or our case law could not have said, you know what, let's continue with preponderance of the evidence. It's just, it's in the nature of a civil case. We're going to keep that standard. We can't do that because we'd be violating the law. We have to follow the Santosky versus Kramer mandatory authority here. So if you looked at section 26, 26 is all about the trial. However, I don't know if we talked about this or not. The first paragraph of 26A, says if the child is identified by the court, blah, 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 the court may excuse the child. What does that mean? The child being identified by the court. Anybody by Karen? So if this is the Karen, in the scenario that I gave you with where Mark was the dad and Amy was the child, then the case would be, protection of Amy, so it's not Commonwealth versus, it's not DCF versus, it's about the child, yeah.
Is it that some children they give false names to, so they're not identifying them literally?
I never heard that answer before.
Well, in some cases.
Why would Amy need to be identified by the judge? Would Amy necessarily go to the court proceedings? Joe?
She's probably not going to be there.
She's probably not going to be there, because notice how it says the court may excuse the child from the hearing and shall proceed to hear the evidence. So at some point, the social worker or whoever has temporary custody is going to bring Amy in. Judge is going to say, "Hi, Amy. What's your name?" I'm Amy. How old are you? Or whatever. Okay, you can go now. Because Amy's not going to be sitting there hearing all the bad stuff, right? When you think about it. Although next week we're going to be starting child sexual abuse, and I have a packet that I will give you, which was a real case many years ago that I was involved with. And believe it or not, and you'll hear more about this case, but it's one of the few cases where the children attended, because the children recanted, and said they wanted to be with Dad. While they weren't in Dad's custody, he'd show up, they'd show up, and they'd sit in the front row of every court hearing with their dad. And that was very unusual, because you don't usually see the children unless for one reason or another, either the judge ex parte might be interviewing the child, or if the child testifies for whatever reason. But for the most part, children are not there. So they get identified and that's it. So because they're the subject of this petition, basically, right? So it's in Ray, it's care and protection of Amy. I need to know that there's an Amy and that someone can bring her in and I can, identify that that's Amy.
I'm sorry, so that just means that they're not there when they say the child is identified? That just means
It means that I, as the court, and she needs to be identified just once, and that's it. And then she can be excused. She doesn't need to be there,
So she has to come
basically.
in once.
She has to come in once. The judge has to look at Amy and, for identification purposes, and know that that's the subject, child, or children of this petition. And that's subsection A. Now, subsection B deals with the adjudication phase of the case. Adjudication as opposed to disposition. And you might have heard these these terms in criminal. So you have a criminal case and the Commonwealth proves, beyond a reasonable doubt that the defendant did it, proves the elements of the crime or whatever, and then the judge finds the defendant guilty. That's the adjudication phase. Then it's like, okay, now what do we do with the defendant? And the dispositional phase has to do with, let's look at probation, sentencing guidelines, all of that. So when you look at this second paragraph, if the court finds the allegations in the petition, remember 11924, that first paragraph, that the parent is, for all purposes, unsuitable, currently unfit, and that's the term, that's the standard, to take care of his or her child today at the time of trial, 15 months later or more. Then the court adjudges the child in need of care and protection. So that's the adjudication. So it's not, you're finding somebody guilty, you're not finding the parents guilty of child abuse, it's not a criminal case. You're adjudging the child or the children in need of care and protection. And then you look to the standards and the guidelines, and this time, I don't give you, while it looks like I gave you a lot of cases on the CD, there are tons of cases that go up to the appeals court, go up to the SJC, because parents as of right, can appeal these cases when they lose. So there are countless times when the appeals court and the SJC makes determinations about whether the lower court erred in its findings, in finding, parents unfit, and there are different various reasons, depending on the type of abuse, the type of neglect, that a parent would be currently unfit. But notice I keep saying the focus of the care and protection case is current parental unfitness. However, and this goes to that worst case scenario that I mentioned in the beginning, and it's in 11926. The judge has various dispositional alternatives, ranging in, okay, I'm going to judge the, Amy in need of care and protection, but she can stay with Mark, up to worst case scenario, I'm going to judge Amy in need of care and protection. Not only is Mark currently unfit, but I'm going to dispense with his consent to adoption, because it's in the child's best interest to do so. And this was a change. It sounds like it's been around for a while, but in my history of representing, parents and children, it hasn't. In either 1994 or 96, I always forget the year, the statute changed to incorporate allowing the juvenile court judge to do what I just said. So to me, it's still sort of, I don't know, unreal that a case that starts out with the department who is entrusted to help families can turn into a case where you end up terminating parental rights. Chapter 210 that I gave you is actually the adoption statute. And it's the adoption statute that used to be under the penumbra of only the probate and family court. So what would happen is parents can lose custody under Section 26, and they haven't lost parental rights, right? They still have, for example, one of the cases that you read was custody of a minor. Let me, so in between, put the trial down here, 11926. Some of the issues that come up is, say, visitation, custody of a minor. So whether the parent loses custody temporarily way up at the emergency hearing, 72-hour hearing, or even loses custody, you know, as a result of trial, parent still has right to visitation. What was the standard that the court talked about in custody of a minor in terms of visitation issue? For a court, Jenna, to stop visitation, Stephanie?
Yeah, the SJC held that before terminating visitation rights, the judge must make specific findings demonstrating that the parental visits would harm the child or public welfare.
Say that again louder.
Before terminating visitation rights, a judge must make specific findings demonstrating that the parental visits will harm the child or the public welfare.
Yeah, so harm, state, and it's the state that ultimately has to show that, has to show harm. So a number of issues revolve around this visitation problem. So a parent could maybe get denied visitation very early on. You know, Mark calls Uma, his attorney, and says, you know what, I haven't seen Amy. And this is like 2-3 weeks after. And Uma says, what do you mean you haven't seen Amy? The department is supposed to be offering you, you know, visitation. They haven't contacted you. And Mark says, well, the department said something like, yeah, that I shouldn't be able to see her. And they're not going to provide visitation right now. That should ring a bell to you, maybe, in terms of 2 other cases that you had to read for today, for Thursday. The companion cases of Isaac and Jeremy. So is, number one, for the department under 110 CMR, code case law, the department is doing something wrong here, right? Custody of a minor, not giving Mark the right to see his child when the trial is not going to happen for at least a year and a half. What is Uma's recourse as Mark's attorney when he hears that the department is not providing visitation? The department as an agency made some agency determination, but that determination is against the law, isn't it? Well, you're only at the trial. When you say appeal it,
Doesn't the judge just make a decision on if it was correct or not?
say that again.
Doesn't the judge just make a decision on whether the department did something okay?
And so how do you make that happen in light of Jeremy and Isaac? And you have to be careful, right, that what you're asking the judge to do is, you know, not beyond his or her authority. Let me just back up for a moment. What did the judge, in the Isaac and Jeremy cases, and I forget which one, but one was temporary custody and one was permanent custody. What did the judge do wrong there?
Well, did it have,
No, you can go ahead.
I was just gonna say with the evidence that was before the judge, right?
No, what the judge did wrong here is he overruled the decision of the DSS, and they wanted to place the child in a specific spot, and he said no and overruled them, and it was his position to determine what they could do with a child in their custody.
Custody, going back to the definition of custody into section 21, once DCF gets custody, starting from the emergency, you know, and or the 72-hour hearing, think parents patriae big picture
Because
again.
their rights of custody are equal to a parental right once they
Exactly,
receive it.
yeah, determine the place of abode, to enlist in contracts, etc. So unless, right, unless what? When can DCF's sort of decisions and determinations be intervened with, be interfered with by a court? I mean, in terms of what the judges did wrong in Isaac and Jeremy, it's the whole separation of powers issue, right? The judiciary couldn't do something that was the agency's power to do. The agency had the right and the duty relative to placement, so the court couldn't interfere with that because of separation of powers. But the court could when the department's doing something wrong, right, Amy? So in the scenario that I gave you, what is the department doing that's wrong? And I'm using sort of a loose term, wrong. You can correct me with what the standard is. What would you be arguing if you were the attorney for the arbitrary, capricious, in violation of law? So you'd be filing, and it's not in your paperwork in terms of the Isaac and Jeremy cases, but it has become customary for attorneys to file today what are called motions for abuse of discretion. That the agency, by refusing visitation of Mark with Amy, has abused its discretion, has not acted in accordance with law, with its guidelines, with the custody of minor case, et cetera, et cetera. And then, and only then, could the judge, you know, interfere and make some sort of decision. And the judge would be saying, well, you know, you couldn't just, as an agency, do that. You could come before, you could say it was a really horrendous, you know, physical abuse, sexual abuse case, and the department said, you know, did arrive at a goal of, you know what, the parent should not see the child because parental visits would harm the child. In that event, they still would have to go before the judge and, you know, get, you know, some ruling in terms of the judge making findings that visitation would harm the child. So Isaac and Jeremy works, can work, again, to a parent's benefit, but only in cases where the department, or the argument is the department has abused discretion.
If the parent doesn't fight for that in the beginning, kid gets taken away and the mother doesn't show up for a while, but 3 months later she gets herself rehabilitated, can she fight for that right then?
I'm going to give you a case. It's MECD, and I'm afraid to say the name because I know the real name. And it was one of the judges in the juvenile court that what it just brings to mind the question that the parent's attorney or the child's attorney, I forget, kept bringing actually abuse of discretion motions that the judge wasn't ruling on. Yeah, and that was one of the issues when the case went to appeal. Now it could be too in sometimes parents don't know their rights, so it might be a long time before it's even brought to anyone's attention that the parent isn't getting visitation for whatever reason. Yeah, Karen.
The answer is yes.
Parents,
in
they're
my
not going to lose that right. That right doesn't go away.
Go away just because they haven't shown up. And I've had parents show up, lots of parents show up in the absolute last hour before a termination trial, and you know, their rights are still there.
And it's always, until parental rights get terminated, the department's goal is still to provide services. And that's one of the services the department should be providing. Another sort of abuse of discretion sometimes has to do with placement. So they yank Amy, and Mark says, well, I have a sister that lives in Tewksbury. Can Amy go live with her for now instead of a foster home? And then Mark learns that they didn't even follow up, and do any kind of investigation, whether that's a proper placement. So again, the attorneys might be bringing an abuse of discretion motion because the department hasn't followed its goal, its mandate to, keep children in families. So those are the most typical in terms of using Isaac and Jeremy to argue in the juvenile courts.
But wasn't Isaac and Jeremy with a court overstep?
Yes,
So-
absolutely. The
so-
court overstepped because
so-
the court could not make a direct order as to placement
So how
because
did
the
the
department had custody.
But then how did the department?
Somebody answered that, Elaine, who said before arbitrary and capricious.
But, right, the judge. But then how did the department abuse their discretion when they weren't allowed to make the decision?
Not in Isaac and Jeremy, in my hypothetical, right? In my hypothetical. So that's, again, the judges can't make orders like in Isaac and Jeremy that are beyond the judge's authority. So think of it, again, it boils down to that term custody. That term custody is so all-powerful in terms of what the department is able to do and has the powers and the duties to do, unless the department is violating violating the law. Whether it's their rules and regulations, whether it's statutory law, common law, and you would know about that, again, if you have the relationship, and attorneys should, with the parents, because, from when the children are first taken and from the custody hearing until the trial is a long ways away. And because you're not going to court that often doesn't mean that things aren't happening within the agency. Okay? So I mentioned before, for example, Mark's right to a fair hearing initially. The agency also holds, for example, what are called foster care reviews every so often. Parties have the right to be there, to participate, to appeal even within administratively what the foster care review hearing officer comes up with. Karen?
Yeah, they're every 6 months, and
Right.
attorneys are allowed to go to those
Yes,
as well. So
yeah.
if you're representing child or the parents, you should be going to those also.
Right, and because you've been appointed, and this is important, because if you've been appointed by the court process, your entire representation concerns the way that the parent interacts with the agency, and you should be going to anything administrative, and you should be, appealing decisions that, your client has brought to your attention, or that you realize is somehow, unfair, or violates due process, or violates their rights in any way. Another thing that happens, and that's the Bruce case.
I'm sorry.
Yeah, Joe, go ahead.
I'm confused about this. We have two different series of procedures going. One that's
That's
happening
right,
in DSS
because
and
one is
that's happening in
agency
court.
law, one is court.
Okay, and the lawyer for, let's say, the parents can be going to both.
Absolutely,
things.
should be.
And all the information from the agency hearings is getting filtered into the reports that are going to for the court hearings as well, or are they?
That would be a really lengthy answer. Let's take it a little bit step by step.
There's two whole procedures going on, and you're working within both. So if custody was being denied, am I going to go to try to work it out through the agency first, or am I going to go right to court and try to get most of the
Okay. Remember when I explained the DCF duties after investigation? After the 51B reporter substantiates the 51A, there's a longer process, the assessment process, that usually takes about 45 days. And then again, usually 10 days after that, it's supposed to be 55 days after initial 51A, the DCF comes up with a service plan. And then those service plans are periodic as you're, working with a family. So if you had been appointed as the attorney, all this stuff is going on, and at the same time, you might also be going to court. So for example, you might be going to court, and what did I say was the social worker, Elaine, will be coming to court with her letter, with her status report, and under both the Bruce case that you guys read and 21A, the court can accept that report, even though it has hearsay, and that report is sort of summing up what has been going on. So it could be summing up as well, the service plan, what the parents are doing, what's going on with the children. So it sums up sort of the administrative piece of it, and the court is hearing that through Elaine appearing in person. And that's why she can submit the report that contains hearsay, because she's appeared in person and she's subject to the parties questioning her. It's really important in the past, and hopefully not as much in the last few, I don't know how many years. In the past, attorneys didn't get so involved in the administrative process, and very much, to the detriment of the parties involved. If you're appointed to represent somebody that's lost, custody of his children, and you have an agency that's doing stuff, administratively, and not only you have a right to be there with your client, but you're going to get paid for it. You're going to bill for it. In the cases, though, where the department never filed a care and protection, this stuff still goes on. Assessment, service plans and whatnot. Parties are not getting attorneys administratively. It's only if they had hired, attorneys on their own. So that's the status hearing. That's the Bruce case. Frequently, I don't know, it might be every month. Again, it depends on what's going on in the case. The motions for abuse of discretion might be another reason you'll be coming into the court. And so these are all different hearings that would occur between the temporary custody hearing, the 72-hour hearing, and the final hearing, which is under 26 that I just mentioned. Now, you also had to read Zelda. The intervener case, right? What were the relatives seeking to do unsuccessfully in the Zelda case? Mark?
Well, here there were 4 children by the one mother, 3 different fathers. 2 oldest were adopted by a sister of the mother, who was also living with another sister. So the 3 sisters were together, and they were trying to adopt this last child, who the father sought paternity action successfully, and he'd been paying child support, and he wanted to obtain his child, and these sisters were all trying to knock him out of the picture, basically, and keep the child Ned.
Knock him out of the picture by doing what?
Within the child.
Well, within the care and protection case, what were these relatives seeking to do? Who are ordinarily who are parties in a care and protection case?
Usually the DCF and the parents who have the child, the
And
aunts
the
were-
child,
and the
right? So
child.
it's the pyramid, the three-part child family state, right?
And here, instead of the DCF, it was the aunts who were acting in that behalf, basically trying to petition the state for permission to adopt a child of the father who.
Well, they weren't really seeking to adopt. They might have been thinking of adopting, but within the care and protection case, what were they attempting to do? Okay?
They were trying to file a motion to intervene.
What does that mean?
Once you are allowed to intervene, you have full litigation rights. So they would have been parties.
Mhm, mhm. Why weren't they allowed to do that? And why did the appeals court say they?
Because they had nothing at all to do with determining whether or not that father was a fit parent. They had no standing.
Well, was that really the rationale in terms of,
Yeah,
what's
no.
the standard for allowing in like another kind of case, a party to intervene? Leslie?
The court said they didn't have a liberty interest under the Constitution because they weren't, they didn't have the children. They weren't the biological parents, so they weren't really losing anything. So they didn't have the right to fight this in court. You know what I mean? Only the parents have that right because they're the ones that are losing the liberty of having those kids.
And these aunts
And
had no more rights than grandparents.
They were foster parents. They were considered foster parents.
Mm-hmm,
Even though they were related to the child, they were still the child's foster parents, and they had no standing.
What's the rule that the court, let's talk about this rule 24A that the court, and that's the standard for intervening. It's in a footnote. Amy, you're shaking your head?
No, it said there it had, they had to be appointed as next of friends.
No, I'm looking at the actual language of Rule 24A.
Okay.
What does one have to show if they're seeking to intervene in any kind of litigation under 24A?
You have to claim an interest
Yeah.
relating to the property,
Yeah.
which is the subject matter of the action.
Keep going.
And is so situated that the disposition of the action may, as a practical matter, impair or impede his ability to protect that interest.
And so what did that mean in terms of the relatives here? How did they fail that test?
Well, the disposition of the fitness of the biological father wouldn't necessarily impede their ability to protect the child.
Mm-hmm. What else, Karen?
They weren't necessary to protect the interests of the children.
Mhm.
The children had attorneys that were representing them at this point. Of course, the department is in there. And so these relatives were not necessary to protect the kids'
Mm-hmm.
interests at this point in time.
Yeah, for the most part, and you're all right, I'm just sort of trying to get at, all the reasons why someone, foster parent, another relative other than the party to the litigation may be able to intervene. It's funny because in the last year, and I'll remember the facts more, but we had a case where actually a grandmother was allowed to, and the first thing the judge brought up was, what about Zelda? The grandmother through counsel actually filed, just like they did in this case, a motion to intervene. But what was different in our case, and this was just at the trial level, was that the mother, grandmother's daughter, was mentally ill. And that was the big sort of deciding factor. in terms of the judge allowing, you know, grandmother to intervene. And grandmother had, in fact, taken care of the baby from, you know, day one almost. So there are situations when you might be able to distinguish Zelda, but for the most part, and when you think about foster parents, and even relatives that have sort of temporary custody, yes, they're not parties, and also all they have they have a contractual relationship with the department, so they don't have, you know, the interest in the litigation as a party. Although the statute says there are instances where the foster parent can come in and observe and be a part of the proceedings in some way, but they're not parties. They're not going to get attorneys. They're not going to be allowed, for the most part, to intervene. And that's pretty much the law. But there are situations, as I said, I thought of one in the last year that the judge did allow grandmother to intervene. So
I have custody of my granddaughter, and I have custody of another little girl.
Yeah, yeah.
I'm the permanent legal guardian of each child.
Yeah, yeah.
But it's not through DCF at all.
Yeah.
So I have rights, right? I mean, if the parents, my 14-year-old.
Well, yours is a just different situation because you've already been appointed a guardian.
But even though I'm a
so,
permanent legal guardian,
yeah,
as you know,
yeah,
doesn't mean adoption.
No,
I have a right to adopt these kids.
No, no. But say that there were allegations that you were abusing or neglecting, you would become a party to proceedings where, if in fact a care and protection case was started against any of these children, you'd be like the parent that gets appointed counsel and whatnot because you are their guardian.
So I would.
Yeah, yeah, yeah. You wouldn't be like the relatives in Zelda.
Right.
So don't worry about that, Lizzie.
All right.
Yeah, although you might get them removed, but.
I had a case where the little girl was placed with her grandparents, and DCF had temporary custody. They did the trial, terminated the rights of the parents, and then when they were deciding where the child was going to live to be adopted or not, at that point in time, the grandparents motioned to intervene, and they were allowed to. So, you know, at that point, the parents are out, and at that point, the judge. But they had been going to the proceedings. They had, you know, were very aware of what was going on.
Right.
But they weren't parties until later.
Until then, yeah.
So there's a different, they're saying there really is a different definition of unfitness in this case, in some ways. I mean, the case is saying in a care protection proceeding, custody belongs to a parent such as Sanchez if he is not unfit. And
right, that's the standard that I put, I didn't put it on the board, but under 11926.
But in virtually every case where the department takes away a child, it's because in places of foster care, it seems like the reason that that would happen is because the parent is unfit.
Well, you only have to show unfitness at time of trial. So before then, you're removing or you've initiated a petition because the child is being abused or neglected, right? And then the judge continues custody with the department if the child, if putting the child back would endanger the child, would put the child in further danger of abuse or neglect. So it's only at the time of trial that the focus and the standard becomes parental unfitness. And you know, I started to say before, and I'm not going to have time to talk about the investigator's report, so we'll do that along with domestic violence on Thursday. But keep in mind that unless they lose their parental rights, unless the judge decides, worst case scenario, and incorporates 210 section 3, that not only is the parent unfit, but we're doing away with the parent's consent to adoption, terminating parental rights. I'm sorry, I just lost my train of thought. If the judge is only giving custody to the department and not terminating parental rights, then the case is really, even though there's an adjudication that the child is in need of care and protection, that case remains open in the court. It remains open within the department because a child now is in some other custody, be with a suitable person, be with foster homes, be with, relatives, and the court holds under 29B these annual reviews where the court, determines if continued placement is still in the best interest of the child. So that's by court order under 29B. The parents can also come before the court on what's called a review and redetermination. Hey, here I am, it's 6 months later, and I'm clean, and I have an apartment, and I want my kid back. And that's under Section 26, review and redetermination. Because you haven't lost your parental rights, you only lost custody, and now there's a change of circumstances, and you're trying to prove to the court you're not unfit anymore. But you lose all of that if you've lost parental rights, and your only recourse is, at that point, appeal. Arguing that the trial court was somehow wrong, erred in, abuse of discretion or whatever the standard it would be for terminating your parental rights. So I'd like to talk a little bit about the investigator's report, the role of a GAL. Karen, will you be here on Thursday? I want to talk about guardian ad litems a little bit, and as we sort of proceed to domestic violence, and that plays also a key part in those types of cases as well. So we'll do that on Thursday, and I'm hoping to, by Thursday, if I don't have it ready, I'll give it to you next week, give you the packet, because as you're going to be reading the care and protection child sexual abuse cases as well as the criminal child sexual abuse cases, you're going to have this case study that I'm going to give you. I'll need to give that to you on Thursday. And a lot of that is, I don't have it electronically because it was a very old case, so I have a sort of a huge packet that I need to give everybody. So if I get photocopied in time, I'll give it to you on Thursday. If not, I'll give it to you for when we start doing the cases next week.